A federal judge in Maryland had delivered another legal setback to President Trump's controversial Birthright citizenship order, ruling late Thursday that his administration cannot deny citizenship to children born in the United States to parents who are in the country either illegally or on temporary visas. The decision marks the fourth nationwide block on the policy since a pivotal U.S. Supreme Court ruling earlier this summer. U.S. District Judge Deborah Boardman issued a preliminary injunction fulfilling her earlier statement in July that she would take such action if the case was returned to her by an appeal court. The Fourth U.S. Circuit Court of Appeals sent the matter back to her at the end of last month, clearing the way for Thursday's decision. The policy at the heart of the dispute has been tied up in the complex legal battle for months. Since June, two other district courts and other appellate panels have also stopped the Birthright citizenship order from taking effect across the country. President Trump signed the executive order on the first day of his second term. It declared that a child born on U.S. soil would not automatically qualify for citizenship if one parent was undocumented and the other lacked U.S. citizenship or permanent residence, or if both parents were present in the country on temporary visas. Under the directive, federal agencies were instructed to stop issuing citizenship documents to individuals in those categories within 30 days. The announcement sparked immediate legal challenges. Most constitutional scholars maintain the Fourth Amendment, adopted in 1868, guarantees citizenship to nearly all individuals born on U.S. borders, regardless of their parents' immigration status, except in very rare cases. The Trump administration, however, argued that the amendment's citizenship clause does not extend to children of parents who are in the U.S. unlawfully or temporarily. They point to the constitutional phrase, and I quote, subject to the jurisdiction and support of the United States, claiming it implies full allegiance to the country, which they contend such parents do not hold. Earlier this year, Judge Boardman had already issued a nationwide injunction blocking the order, but in June, the Supreme Court's 6-3 ruling altered the legal landscape, limiting the scope of nationwide injunction. The justices allowed the administration to narrow these orders, but only when they extended beyond what was necessary to fully protect the plaintiffs involved. The decision did not immediately clear the way for the executive order to take effect. A court in New Hampshire quickly froze the policy nationwide in a separate class action lawsuit, taking advantage of an opening left by Supreme Court's opinion. The court also sidestepped the broader question of whether states are standing to sue over the measure. In a related case before the Ninth Circuit Court of Appeal in July, the federal government argued that any block on the order should be limited to states that filed the lawsuit. The states countered that such a limitation would be ineffective given that people move freely between states. In Thursday ruling, Judge Boardman certified a class that includes all children born in the U.S. after February 19, 2025, who would be impacted by the executive order. She wrote that the plaintiffs had strong likelihood of proving the policy unconstitutional under the Fourth Amendment citizenship clause and that they would face severe and irreversible harm if it were enforced.